All right, good morning. Hello, everyone. I'm Elizabeth Pollman from the University of Pennsylvania Law School, and it is my great delight to be here this morning with you all as part of this celebration of Henry Hansmann's book, The Ownership of Enterprise. Like many in the room, this also touched me in my work early in my career, and some, I guess, midway through their careers. And it has been so influential in shaping my thinking on everything from nonprofits to startups. So I thank you so much, Henry, for that. And I have the pleasure of moderating this wonderful panel of related work. I think we're all honored to call it related work. We have Rick Brooks, Ron Gilson, Rob Sitkoff, and Richard Squire. I may rename myself Elizabeth. It's all ours today. And I'll hand it over to Rick to kick us off. Thank you so much, Rick.
Thank you, Elizabeth. Put on the little microphone. Zohar, thank you for organizing this. And Henry, thank you for, I don't see where you are. Oh, thank you for everything. You know all the ways that I can mean that. It's really a privilege to be here. Not just for a great conference, not just for a great man, but also to be among great friends. I'm going to just dive right in and then save more of the mushy stuff for later on. The title of this talk is Personality, Contract, Ownership, and Organization. In organization, I really want to emphasize the first three elements there are, I'm going to be using them specifically as legal ideas. They're not strictly legal. They can be used in other ways, but the importance that they are matters of law is where I want us to begin with. And let me start us off with a little quote. This is a statement from oral arguments for a case before the Supreme Court in 2008. Justice Roberts observes to the person arguing, one of the points you mentioned earlier is that an Indian corporation, and that's a concept I don't understand. If Justices Scalia and Alito form a corporation, is that an Italian corporation? Laughter. Mr. Frederick, I would beg the indulgence of the court in not answering that question specifically. More laughter. And do we get special loan guarantees? Chimes in Scalia. More laughter. The room is fully engaged at this point. And then Justice Robert follows. I understand the concept of a minority-owned or Indian-owned corporation, which is to say, I understand ownership. I understand what ownership means. But the point here is you're trying to say that the corporation is the member of a tribe, and I just don't know. I certainly don't think the state, when it incorporated this entity, said, you're a different type of corporation than every other, I can't really see because the thing is cutting me off, every other type of Indian corporation. To which Mr. Frederick responds, well, to the contrary, Mr. Chief Justice, there's a state Supreme Court case on point called, it should be called, that's a typo, not caller, called Poirier, which we cited in our brief, which says a majority-owned corporation under South Dakota law shall be treated as a member of the tribe for tax purposes. That were at issue here. So this is really interesting to me. This is the Supreme Court, and they're struggling to understand this. Now, Poirier is a very straightforward case. Poirier is a case involving a Native American business. They formed as a corporation and had to pay corporate state tax in the state, which was, they challenged because had they formed as a partnership, they would have been members of the tribe, natural persons who are not subject to the tax. And the Supreme Court of the state basically said, why would we want to penalize these individuals simply for the choice that they, why would we want to tax them, take away their right? We shouldn't let something like the form that they've chosen this form be a penalty and allowed, and therefore, the reason why I'm mentioning that is literally that it's exactly the same logic that Alito wrote in Citizens United and was signed off on by Roberts and also by Scalia. It's literally the same thing. There are a bunch of individuals who combine their money. They have free speech rights. Why should we penalize them because they have formed a corporation or a union? It wasn't specifically about. So it's stunning to me, actually, how tricky, how much confusion pervades when people start thinking about corporate persons and ownership and rights. And so this is what I want to say a little bit about. Can you imagine someone being confused or confusing mother-in-law with a biological mother or the mother of dragons? Yet somehow in law, natural persons are always conflated with biological persons. And even more strangely, they're distinguished from corporate persons in law, as if there's some natural or inevitable difference between these entities. So one thing, just as lawyers and also as economists or anybody that's thinking critically about this, one thing you have to recognize is that natural persons exist in law purely as a matter of law. A natural person in law is as much a legal concept as a corporate person in law. Now, there may be reasons why, we sort of other natural persons exist outside of law. Of course, we all are commonly we think about that, but also so do corporate persons exist outside of law. So what I'd like to emphasize, at least initially, is that the juridical person, the legal person, that's the primitive skeletal person in law. Every other person, including human beings that we characterize as natural persons in law, get fleshed out after the fact. They get fleshed out, and this is this notion of corporate veiling, this unwritten paper. I know it's unwritten because I promised Elizabeth I would write it, and I didn't follow through. Before there's veil piercing and removing of the veil, there's a lot of veiling that happens. And all of that veiling has legal consequences in exactly the same way it does for Citizens United and the way it does for Poirier. It's what we do in law. So, so what? Okay. Henry doesn't fall for this, but Jensen and Meckling tell us that we have to watch out for this kind of working too much into personhood. The personalization of the firm is seriously misleading. They wrote in their famous 1976 article. Writing several years later, Jensen separately recalls Herbert Simon and says, as Simon emphasizes, the definition of the elementary unit of analysis in science is not a matter of right or wrong, but rather of usefulness. Whether one chooses the black box or a nexus of contracts, the definition of the organization depends on the question of hand. It's a matter of choice, he says. However, it's important to remember it's just a convenient abstraction that's that's appropriate for the analysis of some questions. The danger arises from this tendency to personalize the organization. So what Jensen's doing here is it's a little bit of a sleight of hand. It's true that for us in the academy or organizational scholars broadly, whether we choose a black box, a nexus of contracts, a machine, whatever the term is, it really is a convenient choice for us. And we should choose in a way that makes it most useful. But a person in law, that's not a convenient abstraction. The moment that the law, the court decides that this is a person, that X is a person of a certain type, certain legal and economic consequences follow. They just do. It's not a simple choice, it's a choice with consequence. So it does matter, it does matter. So let's think about how, am I at 10? Okay, great, I'm halfway. As I went back and I read the book, I was drawn to the Coasian contrast and the way that Roberta and Chuck mentioned it yesterday. And when Coase, I titled this the interwar period, when Coase was a socialist, he was a socialist that came from the London School of Economics to figure out what was going on. And he was interested in the question of vertical integration. It was an economic problem. And in his Nobel laureate lectures, and also separately, he had mentioned that what really drove this question for him was a bigger problem, a bigger political problem. He was thinking about Russia, and that Lenin's suggestion that he was going to run Russia like one giant factory. And of course, he's also, this is the period of the socialist calculation debate, suggesting that was simply impossible. But he saw, in fact, in real life, you had some companies, General Motors versus Ford, differentially organized. So he wanted to figure this out. It was a question. And to that question, he brought some abstractions, marketing costs, what would become eventually agency costs, and maybe even more generally transactions costs to answer this. I should mention, my understanding is that Henry came very much to the topic too, from a broader political and I used the, after the colon, the Cadillac, because of course the Cadillac was a big part of the Fisher body story. But there's another vehicle, the Yugo, and in conversations with Patrick Bolton, so this is the Cold War period, when Patrick Bolton was a socialist. And I mentioned, so we, the students in Paris, maybe students more broadly after the protests of 1968 in Paris and in much of the West, had rejected Soviet-style communism, and so had Yugoslavia, of course, broken away. This is at the bottom, you can't see it because from the State Department, really recognizing that Yugoslavia broke away from Soviet influence in 1948, and certainly by 1961 was really operating in a more decentralized way. But the Yugoslavian worker-owned cooperative was held up as the ideal. That was the alternative that the students, the socialist students understood. And as Patrick mentioned, it wasn't really until years later when he had a chance to read Henry's book that he really first understood the cost and benefits of ownership by workers, by investors, by the state, and so on. So these larger political questions, whether or not they are in the background or whether or not they're consciously in the minds of the students or people engaging with these questions. I don't know if you were actually thinking about anything along those lines, Henry, when your advisor was pushing you to think more about the nonprofit, the cooperatives, and eventually making your way to the regular C corporation. But I think these political questions are always operating in the background. And I want to emphasize here that both Coase's transactions cost answer and Henry's let's think about ownership answer, and they are answers to questions. They were the question wasn't ownership, the question wasn't transaction costs. The question always with COAST was why are firms vertically integrated? What's the best way to organize economic activity exclusively through markets or through some type of vertically or horizontally integrated entity? Henry's asking why are entities structured in this as cooperatives versus firms versus partnerships? The answers that they provide and were entirely non-ideological. Ownership, the transactions costs. These were tools that were brought to bear. The questions may have been driven or underscored in some sense by political considerations, but these were questions these questions generated answers that were non-ideological tools that are useful for us. Okay, let me move a little bit faster. So in 1999, Henry came to UC Berkeley and presented a draft. I found the word perfect draft in my office in Ollie Williamson's seminar, an early draft of the essential role of organization. And Henry, with the grandeur that he mentioned with his titles last night at dinner, Henry begins this with Bernier begins the sentence: in every society, you know something big's going to happen after that. The law establishes a standard set of entities. In the United States, these entities include, and these were the questions that were, Henry wanted to figure out what's going on with this. I mean, this is after the book. The business corporation, the cooperative, the nonprofit, the municipal, the limited liability company, the general partnership, the limited partnership, the private trust, charitable trust, and marriage, Why stop at marriage? Why not a wife as a standard legal entity? Or maybe a husband. We know from Blackstone that the wife disappeared. Her separate, distinct legal personality disappeared on marriage under the doctrine of coverture. It didn't actually disappear, but her legal privileges when the husband went off to war, she reasserted her certain rights to enter into contracts that were enforceable against her. When he was home, she was again subject to that disability. So it didn't fully disappear. It was always contextual. It always depended on the context, the political, economic context. But the husband, certainly, if you want to hold on that the wife is not a standard legal entity, the husband certainly is. So now we're back to thinking about how should we think about this person or this entity, and what are the convenient abstractions and what are the legal ones? Because the moment you're determined a wife, that has real legal and economic consequences. Your husband dies intestate, you get resources. If you're not a wife, you don't. If the Supreme Court is saying only a man and a woman make a wife, only a husband and a man can form a marriage, and then it all matters. I think all I'm trying to emphasize here is the distinction between what we do as academics and the notions that we play with that are useful and important, and what the courts do when they're playing around with personalities. So nexus of contract is very important. And Henry emphasizes that in his piece. And he also shows different ways that we can think about the contract, both legally and non-legally. So the organization as a signatory is an important idea for Henry, but also so is the idea that it's the organization is a bundled set of assignments. So we're thinking about subsidiaries, wholly owned subsidiaries, that solves the diverse ownership problem. That's essential. But it may also be the fact, I'm running out of time, so I'm going to jump. It may also be the fact that this is a thing about its possibility of creating some efficient personality. So if it's a nexus of contracts that we're going to be using, contracts always presuppose a legal personality. So it's not like one or the other. If you're talking about contracts, you're necessarily talking about legal personalities. And these legal personalities are repositories of rights and duties, but a bunch of other Hofeldian powers, privileges, and immunities, from limited liability, free speech rights, powers to engage in political and economic competition. But the contractualization of the firm can also be seriously misleading. If we forget that personality matters. So let me just end by saying, if we engage in sort of this, what might be, and I put a question mark there, because I don't know, this search for, and I can't see what I'm saying, timeless solutions. We may lose sight of the fact that we don't necessarily need to find an optimal solution, an optimal grand solution to the bigger problem. But we might be running into trouble if we continue to use models that purport to create false dichotomies between the political and the economy. It really was what Ryan was calling for, the necessity of doing political economy, or between the rational and the moral. We're going to continue to contribute to the problem rather than sort of working it back. And I think one of the great things that Henry did was that he really worked it back. He gave us, as Patrick mentioned to me recently in thinking about the student cooperatives, he gave us a very useful way of thinking about a practical and pragmatic way of thinking about real economic problems and what law brings to it by ownership, which again is also a legal concept.
Thank you so much, Rick. And now we have a few minutes for Q&A. So please raise your hand if you've got a question, and we can also go to the Zoom audience. Yeah, Andrew.
So I think I'm hearing loud and clear that you are interested in pointing out the ways in which personality carries consequences, and we should think about that as we use the term. I think it's an interesting way to frame a reaction to Henry's work, because I've always read Henry as kind of, functionally an eliminativist as to the legal personality of the entity, really always asking us to frame it in terms of the behaviors of the natural persons. We can think of the corporation as, a concession that certain assets of mine will be set aside for certain creditors of mine. And we can always tell the story in terms of natural persons all the way back, that that's a useful lens. But I guess your initial comment about how even natural persons are a constructed concept or a legal concept is meant to say that that's not the only place to stop with our eliminativism. We can go up or down as we want. And maybe there's something interesting to read into Henry's work if you take the legal theory concept, the private law theory concept of the person more. Anyway, I guess that's a reaction, but I guess is there an insight that comes from framing it this way or bringing this aspects out?
Yeah, so Henry can clarify or correct, but I think Henry doesn't necessarily rely on the natural person, or even the nexus of contracts, even though I put up this quote from his piece. I think this was just for the context of the assignment of wholly owned subsidiaries. I think Henry thinks that entity, legal entity, whether we call that entity a person or a rights and duty bearing unit or whatever it is, Henry thinks that there's some object out there, there's some legal subject out there, and that legal subject can be the basis and structure of different forms of organization and ownership, and it's useful to pay attention to that.
All right, we have Henry.
All right, am I connected? Okay, well, I think as Rick knows, I pretty much agree with him, and I think he's onto something here. The actors in society are always artificially presented. There are no natural persons out there. There are legal persons that are, well, there are many societies that do not designate individual human beings as legal entities. Rome was famous for that. In Rome, the legal entity was the extended family, the patriarchal family, and the head decision maker was the paterfamilias, the oldest male in the family who was alive. And the Romans never adopted the notion of a business entity or a familial entity as a legal entity. There were some slave-owned firms that partially filled that gap, but the bottom line is the individual was not a legal person in ancient Rome, and they ran a pretty good economy on it. So it's not until the late Middle Ages that you find Europeans moving away from the concept of the family as the legal entity toward the individual as the legal entity. And it's an interesting question, I think, that Rick gives us here, which is what shapes this evolution of the concept of the legal person? Well, I won't try to speculate on what explains it. I leave that up to Rick, but I think it's an important issue, and I think it's important to recognize that legal persons are very much constructs. That meet what criteria, we don't know. What forces the evolution of this concept, this construct, is a hard question, but we'll count on Rick to solve it for us.
I have a few more questions. Do you want to? Yeah. Thank you so much, Henry. Luigi, Zen, and then I think John in the back.
This was just a clarifying question because I missed an important element at the beginning. So you were talking about the Supreme Court and the fact that they were discussing what is an Indian corporation and an Italian corporation. Then you made a link with Citizen United and the logic. Can you sort of go over that link again? Because I would like to understand better. I'm very interested in why the Supreme Court arrived to that interpretation, Citizen United. So the more you can enlighten on that, the more I appreciate that. Thanks.
Sure.
Zen, would you like to go ahead? Yeah.
Thank you. The legal personality is my long-term research issue from the perspective of comparative law and practice. And I think it looks like the way of using legal personality is totally different in the United States and Japan. And this is related to the long-term debate in Germany that whether the personality is real or just let's say fictions. So in Japan, say even the 100% subsidiary considered to be the substantially independent enterprise, and the parent company should give the management of the subsidiary greater autonomy than the head of the in-house divisions. So I think in the United States, there is no distinction from the corporate governance point of view. Of course, asset participation, limited liability is the same, but from the corporate governance point of view, my understanding is in the United States, there is no difference between the 100% subsidiary and in-house division. But in Japan, there is a big distinction between them. And also the Japanese company use that the legal personality or 100% subsidiary for differentiate the salary rate. So that is back to the Mark's presentation yesterday. So legal personality is used in many practical purposes in Japan. And why it is?
I'm going to hold you there because we've got two more and then back to Rick for the last word. So John and then Ed in the back.
Thanks, Rick. I thought this was really interesting. You know, one thing that it made me think of, and maybe this, you can let me know if this isn't really relevant, but, you know, if I work for a company, if I work for Apple, I think there's a good likelihood that I'll be something of a fan of Apple. You know, there will be sort of a shared purpose. I'll go into work. I want Apple to succeed in a way that I might not if I'm a contractor of Apple, even if my contract gives me identical equity benefits, incentives. And, you know, right now there's a lot of questions about who's an employee, who's a contractor. You know, we see that with Uber And I'm wondering if thinking along these lines of some sort of shared purpose, in the same way that a family and a business might resemble each other, and that you kind of have a motivating rooting interest. You want your family to do well, you want your company to do well. If that's something that courts should be considering beyond just the four corners of what's the structure of the contract, what are the nature of the benefits.
Ed.
So I very much like your perspective on this, and there are some current issues that very much fall within what you're talking about that your perspective, I think, would cast light on. So you draw a distinction, I think correctly, between the characteristics of a legal person. Legal persons of all sort are constructed by the law. And in constructing them, it seems to me an important question is, what are the characteristics of the legal person constructed? And you can draw a distinction between that and what legal obligations or what social obligations a legal person has. So for instance, on the much debated question, for whom is the corporation managed, or the objective of a corporation, your approach suggests that one reading of that is that the answer to the question is, in the first instance, what are the characteristics of the enterprise form, the corporation, created by the statute and the case law? And it's a separate question, what social obligations corporations have to behave as good citizens or to look after the interests of various constituencies.
Thank you. So we have 1 minute to wrap up, Rick, which is no easy task.
So I'll just really fast and maybe in reverse, because that'll help me go faster. That's terrific, and that's really helpful. This conflation between the characteristic of the persons and the duties and obligations actually emphasizes that persons don't act, or still, even today, we don't have to go back to some prior aristocratic period where the peers had a certain set of rights and the commoners had. The people still today have very different rights. So how we think about them often implies the right. John, your comment about Apple, I think that's really important. Once we start thinking more carefully about personhood, we can start to think about not just identity, but identification. So there's interesting work by Levitt and Fryer showing how identification with a certain community might actually lead the community, because you can't get out or something, might lead the community to invest more. We can start getting better outcomes, that people, more commitment. So there's a commitment story there too. I think the Japanese story is really interesting, and it does connect back to German and von Gierke's idea of the corporate thing exists outside of law, before law. Law just recognizes it after, and that's just a very different way of doing it. A lot of the world is doing it that way. It's just different than how we do it. Luigi, can I get back to you on the account? But basically, it tracks really so closely that it's odd that they were struggling with the conclusion that they did. And Henry, well, thank you again for all of this. I think just really quickly on this, maybe the change is going to happen from Rome through the medieval period with Enlightenment, and maybe it's what this idea of moving from status to contract that Maine talks about. But we see real economic consequences of that in the US, right? Once we start to see and understand the personality of women, we start to get married women in particular, we start getting the married women's property ownership laws passed, because everyone recognized there was underinvestment in training of girls, because they were going to lose it all. And there was also adverse selection in the scoundrels that would marry them in order to acquire the property. So law started to play a really serious role once we started understanding the organizational structure of the wife. Yeah.
Wonderful. Thank you so much, Rick.
I'm awfully grateful to Zohar for the invitation to participate in honoring the 20th anniversary of Henry's very important book. And more important, to honor the person who gave us that book, as I'll talk about it in a little bit. The book frames very much, in my view, the way Henry looks at the world, which has been an enormous benefit to me. It's difficult teaching, speaking on the second day of a conference like this, because basically almost all of the funny anecdotes have already been told. And I'm hoping there's one left, and I'll try it. A few years after I started teaching at Stanford, I persuaded the school to run 2 different tracks of the basic corporations course. One in which the students would have had a finance course before they talked about entities, and the other, much like we do it now. The non-finance oriented course was referred to as the National Lawyers Guild Corporations course. And since the whole thing had been my idea, it was pretty obvious who was going to end up teaching that course, which actually turned out to be quite wonderful. And this is where Henry's book comes in. In very many respects, the course I taught ended up focusing on, without acknowledging it, on where Henry's book was going to come from. The first week's assignment was an inquiry. Henry will remember this because he's framed the question I've heard a number of times. Was an inquiry into why public corporations were capital cooperatives instead of labor cooperatives. And then we took a close look at the United Pilots Union leverage purchase of United Airlines, but not including the flight attendants in the purchasing group. The new edition of my and Jack Coffey and now Brian Quinn's corporations book doesn't start that way. I would have liked to have started that way, and it didn't not happen because Jack and Brian disagreed with it, but they weren't confident that we could persuade people to adopt it that way. So it gets built in on the side. The paper that I would ask to talk about is much in some way like Henry's approach to life. He sees patterns, and then the natural move is to try to explain what the pattern is. I want to combine talking about how Henry's approach in that fashion animates the paper that I'm going to talk about. It also ties into another of Henry and Rainier's skills, that is the wonderful ear for a title. The End of History of Corporate Law is a good example. No one knew quite where the end was going to go, but it certainly seemed important, just from reading the title, to know how Henry and Rainier were going to play off Fukuyama. Curtis Milhaupt and I lacked, still do, Henry's way with titles. So we linked Henry's work and that of another powerful scholar, Albert Hirschman. Hirschman, like Henry, had the capacity to put together an informal account whose intuition and whose analytic power was so great that you left with the conviction that you must always have known this, because suddenly a whole set of things become much more straightforward. I expect no one actually missed the formal presentation. So in the end of history article, Henry and Rainier saw a pattern that persuaded them that corporate law and organization were converging on an efficient endpoint, a system that promised social benefits by giving shareholder interest primacy. Now, I do want to point out, you'll notice in that formulation, the phrase long-term, maximizing in the long term didn't appear. It didn't appear on purpose because it is one of those phrases that has the capacity to draw any meaning out of a conversation. It's hard to know how we identify the right investment horizon ex ante when increasingly we're talking about innovative projects in connection with which the problem the investment presents is uncertainty rather than risk, as Frank Knight and John Maynard Keynes distinguish between them, so that we can say it, but we have no framework to explain how we move from uncertainty into risk. I don't leave it out because I think we ought to all run in the short run, operate in the short run, but I don't have any more confidence that I know what that means, either. In the essay I'm going to speak about, Curtis and I look at one of Hirschman's less regarded works, Shifting Involvements, Private Interests, and Public Action. Not speaking about, Hirschman is not speaking in this book about corporate governance, business, or anything that focus. He seeks to explain a cycle which he observes in the way individuals invest their time, a shift between public regarding efforts and private regarding efforts. And the cycle in Hirschman's terms is viewed by disappointment. We go in, we invest time in one or the other. We turn out to be disappointed either because our efforts are less successful or the results of our efforts are less attractive to each other. And as a result, we switch back to whichever pursuit we had been ignoring until that point. In this account, and Hirschman's story, there's no end of history. That is, there's nothing in it that says we're going to get to the right place and we will all be public oriented or private oriented, or any particular comment about why either of them are better than the other, but merely that we'll continue cycling. In the paper, we frame the cycle that we're trying to explain as a pattern of increasing capital market completeness, because as we do, the ability to slice into ever sharper pieces the kinds of risk transfer instruments that the capital market makes available, and in turn, the restricted capacity of managers to shelter themselves from the capital market. On the other side, the other half of the cycle is what Curtis and Mariana Parglander have labeled policy channeling, the use of the tools of real government as opposed to corporate governance to design a system that supports corporate pursuit of public policy goals. The story is simply, we go down one road and then we're disappointed in the outcome, and suddenly we see the pattern repeating itself. These two characterizations, Henry and Rainier's purpose-driven and teleological account of corporate governance, and Curtis and my account of a repeated cycle that shifts from shareholder to stakeholder welfare, poses a question. Which one of the two accounts reflects apophenia, the perception of patterns, which in fact are actually between what in fact are unrelated elements? We try to address this by working through what we see as similar cycles that have occurred in different countries at different times and in going in different directions in different countries at those times. If we had the wit to try to turn this into an empirical exercise, I suppose at least the The metaphor would be an event study where the events take place at different times, and hence the regression gets rid of all of the unrelated elements. We look at five examples of this, again, all at different times in different countries and going in different directions. The easiest, of course, is the United States. We start there only because it was easier to write that one first. We'll start by tracing the 40-year cycles of how the Burleigh means claimed that ownership and management had separated, shifted from being seen as a problem that required the intervention of real government to address. Think of Burleigh's attraction to antitrust during his early involvement with the Roosevelt administration. And then being reframed by Alfred Chandler and Jensen and Meckling, not as a problem, but as a solution. That is, what the separation allowed in Chandler's characterization of the development of management practices in the US was that it allowed dual specialization, the specialization of management to deal with an increasingly complex business environment on the one hand, and the specialization of risk bearing on the other, by public markets allowing shareholders to diversify. 40 years later, the intermediation of equity, the reconcentration of equity in institutional investors, gave rise to governance as a way to further shareholder interests by increasing mechanisms by which management was constrained in evaluating the market's evaluation of what it could do. In this respect, think of the intermediation of equity as creating the pattern of activist investors moving away from the Raiders story of the 1980s. Again, the last piece of the US story, now an exercise in policy channeling. I suppose the easiest way to reflect it is the series of business roundtable descriptions, changing descriptions of what the purpose of the corporation was. And the Davos pronouncement that Marty Linton had such a heavy hand in, that one can't help but walk away thinking this was done by a committee. The pronouncement was done by a committee that really didn't agree with each other about very much. Shift back and forth over roughly 100 years in what was driving corporate governance, either the impact of a more complete capital market or a shift to policy channeling where the government was intervening. Second thing we looked at, 3 minutes, I'm going to talk fast. The second thing we looked at was Japan. We see a similar pattern from forceful policy channeling that supported the high point of Masahiko Aoki's J-form characterization during Japan's high growth period to Abe's still halting shift in the government pushing the Japanese system toward more intense shareholder attention and more attention to returns to shareholders. The third was China. We see the development, we talked through the development of attention between the increasing role of private capital as a means to finance the expansion of the industrial base that would then be subject to a party influence, and then the expansion for a period of attention to shareholder returns. Now, since the writing of the paper, the focus on cancellation, going the other way, the focus of cancellation of IPOs and the like. Finally, we've used Hirschman's concept of shifting influences to motivate a broad inquiry into the pattern of corporate governance reform. We track a pattern of oscillations in the relative influence of capital market completeness and policy channeling, one privileging shareholder value maximization, one targeting distribution and social issues. And we show that the pattern is not limited to a single country, to a single direction, or to a single paradigm in time. That leaves the last question, which is, so who gets the better of it? Who gets the apophenia medal, the end of history, or our pattern of cycles? One way to frame the question but not answer it is the literature's fixation with equilibrium. That is, there's always going to be one story, one corporate governance story around which the rest of the solar system, the governance solar system revolves. And let me illustrate it by a talented ecologist response to a request. And this isn't a joke, this is real, who was brought in to provide guidance on restoring a much beloved New Jersey forest. And the man listened carefully, and then he asked, well, tell me, do you want to restore the forest to what it was like in 1650 or 1750 or 1850? Essentially advancing the theme that at least in that area, there is no stable equilibrium. If there's an upset between prey and predator, it doesn't revert to an older, to the past equilibrium. It just keeps going, and you get different ones. The right answer, I think, and it means that Henry's right and we're a little less right, is that how do we design governance structures and organizational structures in a setting in which we're dealing with uncertainty, not with risk? How do we design a system that has the capacity to generate the information that turns uncertainty into risk? And that will there will not be a stable equilibrium in organizational structure that reflects that. Thank you.
Ron, so we've got several minutes for Q&A, if you'd like to stay.
Sure.
I'm looking for hands, and I also see one on Zoom. Eric Rasmussen, do you have a question for Ron Gilson?
I'm sorry.
Got it.
Very improper. I had a question for Rick Brooks and forgot to lower my hand, but Ron would be interested too, maybe. How about the very idea of a person being a legal construct? Now, if you don't want to answer that, because that's really a question for Rick, go ahead.
You got that.
But I was thinking that Henry maybe, or the rest of you, could all go and reform civil procedure, just like property, looking at the bundle of rights in being a person.
Yes, from legal personality to shifting influences on corporate governance. You're welcome to say anything you'd like, Ron, and I'm also looking to see if anybody in the room has anything else that they'd like to ask.
The only comment I'd make is just the one that Eric framed. Henry's framework generalizes really, really interesting in interesting ways because it isn't limited in any formal sense.
Quite so easily, because I now see Albert and Lucian.
Hey, Ron, that was a very illuminating discussion. So my question is, so you sort of briefly talked about US versus Japanese experience. I think I'm totally on board with this idea of, let's say, there are different kinds of cycles as far as the equilibrium is concerned. But how are they different, let's say, across the different kinds of political systems based on, let's say, your studies of the Japanese? And I think Curtis is probably doing more on the Chinese system or maybe the German system. So, I mean, I'm kind of interested in how exactly does the background, the political system, for instance, how does that influence the cycle? How does it affect the equilibrium? And how do we see going forward in the United States from this point on?
Well, I'm going to answer, do the easy answer first and the harder one, and sort of dodge the harder one in a second. How do we go forward? In the last portion of this paper, we draw on Lucian and others' work suggesting that the notion of stewardship and in turn the notion of some ill-framed purpose is going to turn out to be a disappointment, because neither of them are going to be able to frame where we want to go effectively. I've had a running conversation with other colleagues about Costco and Walmart. Costco gets presented because they treat labor really quite well, and Walmart doesn't. As an example of corporate purpose. If you actually read what the president of the company says, it's a perfectly wonderful, understandable explanation of an efficiency wage theory. We make more money when our employees want to keep their job where they can't walk out and get the same job the next time. I mean, it's more clear than Stiglitz's, but I think none of these things are going to get us anywhere. And the distinction between purpose and enlightened shareholder interest is also not going to get us anywhere. And we'll see a push back toward the kinds of organizational structures that Henry's work focuses on.
Thank you. Lucian.
Was fascinated by this broad account of corporate law history. And I am persuaded that we are not going to reach an equilibrium, but keep oscillating. I wonder whether you can, however, whether this oscillation is one where normatively you can assign progress or regression, or just look at it objectively. Namely, are you like the biologist who would say, I can't tell you whether the forest of 1650 is better than 1750 or 1850, just tell you they were moving in different directions? Can Ron Gilson say our world in a particular decade is better than the one before or worse? Can you give us grades as we progress through history?
A short version of the answer. If we take a corporate income statement, every line on that income statement represents the corporation's interaction with a different stakeholder. So that if we assume perfect markets in each of those factor markets, we can forget governance having an impact on anything, because the corporation doesn't have any market power that would let us do that. Once we identify particular factor markets in which we think, one, we can do better, and two, in which the corporation is capable of doing it, a much smaller company like Costco outperforming a very much larger company like Sam's Club, then we begin to get a sense of what it is that we want to accomplish. Within that range, there's a great deal of flexibility to do it. And I don't see any particular reason. Climate change is likely to be the closest in which I necessarily expect agreement on normative principles across the business environment than I do about strategic principles. It may turn out that everything that was disclosed about Facebook over the last couple of weeks we will see it in TikTok in everything in every other, and we'll begin to see a cycle. We'll begin to better understand the cycle of platforms. But I think there's both the system and the nature of the problems, but leaves a lot of flexibility for for people reaching both different answers and different strategies for how to go about addressing them.
We are really very close to time, but Margaret wanted to get a quick thing I could tell from her, the way she raised her hand.
Speak. Yeah. Okay. Sorry. I just want a quick comment on the idea that the balance sheet allocates everything to one set of stakeholders or another, and that's true for everything except externalities. And so the externalities don't get picked up, and so they don't have any representation, and that it seems to me like it's a huge part of what people are worried about these days.
And I think that's right. And what in our cyclical story, where externalities are in a particular industry or more generally are playing a central role, it's going to push toward policy planning and out of corporate governance and into real governance.
Right.
Excellent. I have to say, thank you so much, Zohar, for bringing together this excellent group. It's really amazing, the people that you've brought together today. And thank you all organizers. So we go over to Robert Sitkoff, who I see is ready to go. The floor is yours, Rob.
Okay, thank you. I'm going to ask the host if someone can let me share screen so I can show slides in a minute. But while someone's setting that up, first, let me say to Zohar, thank you for including me. And let me say to Henry and all my friends in the room, I'm really heartbroken not to be there in person. There's a gastro illness going through my house. One of our folks here had to go into the hospital from some IV fluid, and so nobody wants me around. But I'd like to, before we get going, and as folks set it up so I can share screen, maybe I can just say on a word of personal privilege of thank you to Henry, both professionally and personally. So as a student in Dan Pichel's corporations class, we encountered some Hansmann writing. And then as a young law professor, Henry was unfailingly generous. When I went up to Yale to meet with John Langbine, we had a lovely conversation about business trusts. And along with so many of you in the room who I'm so sorry not to see, kind of welcomed me in like the orphaned cousin or something who did trust stuff, was a little bit related to corporations, but was welcoming. And Henry, the role you've had as a friend, as a colleague at NYU, and as a influence as a scholar on me has been profound. I think of my early work on agency costs and trust law, stuff more recently about mandatory rules and fiduciary law, or even the way that almost everyone teaches trust and estates now bears an influence of the work you've done on asset partitioning and otherwise. And so I'm really sorry not to be there, but grateful to Zohar and the rest to have a chance to say a little bit about this. Okay, so I see that I've got screen sharing enabled. So let me put the slides up and talk a little bit about the project I'm doing here with John Morley on statutory business trusts. Are folks seeing is this working? Are we seeing the slides now? Okay, great. So this is a project on the rise of the statutory business trust. It's a project that variously John and I have been working on and off for more than a decade, but now I think is finally getting going. So let me say a word of motivation about the puzzle, and then a little bit more about the puzzle, and then what we're doing with this. So this is the role of the trust in enterprise organization is a question that gets raised episodically by Henry and others. In 97, we have Langbein identifying that business trusts are actually more money. It's a bigger deal in terms of dollars than donative trusts. In 2005, I suggested a research agenda with a series of questions about business trusts that we didn't really understand. In 2006, here's Hansmann with Crackman and Squire identifying that any entity that could be formed as a business corporation, an LLC, an LLP, could be formed instead as a statutory business trust. Maybe the statutory business trust is the final step in the historical evolution of commercial entities. In the ALER lecture that became the ALEA lecture that became the ALR paper, the statutory business trust, first adopted in Delaware, represents the conceptual endpoint, virtually complete contractual freedom with respect to assignment of earnings, control, and even fiduciary duties. And yet we have this puzzle: if this is the final destination and the evolution of enterprise organization, why do so few people use it? And how come none of us understand anything about it? So more recently, John has did some work on common law business trust to rediscover the lost history of the business trust and its use as a substitute for the corporate form. And as kind of a prelude to the current project, John and I kind of tried to break apart donative trusts from commercial trusts and understand these as distinct branches. All right, so this is kind of where we are, which is to say we don't know that much, but we understand there's an important question here. So here's our claim. Our claim is the statutory business trust really isn't so much the ultimate destination in the evolution of enterprise organization, but it's a mule. It's a hybrid entity that it works in its niches. That it has corporate elements. It's a juridical entity. Statutory business trust is a juridical entity. That's its corporate parent, but it has trust law rules. It's trust law defaults. That's its trust parent. And it also has a hybrid attributes from neither, like internal asset partitioning through the series device. So like a mule has some elements of each of its genetic parents, but then something new from this creation. And our claim is that this something new, this mule of an enterprise organization, it fits quite nicely in its narrow niches, but nowhere else. And has an unusual political economy for that reason. Right? Relative to the genetic parents, it's really a lot better than any other form of organization in its niches. And it's just a lot worse than anything else in it outside of the niches. The claim, and this is a standard cost benefit trade-off idea, is that its unusual balance of advantages and disadvantages make it really strikingly valuable in its niches and strikingly ill-suited outside of its niches. And that what goes hand in hand with this is that the organization, the entity itself, has been shaped and refined to, it's been adapted, it's been bred over time to fit these niches specifically, and not really to fit anything else. And our here are two anecdotes about the two examples. One is the series adaptation for mutual funds, but even the better part is the origin of the statutory business trust. So we went and took a look. The Delaware Statutory Business Trust has its origin in opinion letters from Richards, Leighton, and Finger. What happened was RLF was giving opinion letters for use of common law business trusts, was getting increasingly agitated about these opinion letters. And so one of its lawyers, Eric Mazie, took all the opinion letters, strung them together in a bizarre order, and got the legislature to enact them. And that was the first version of the Delaware then Business Trust Act. Okay, so let's put this in a historical background. Right, we'll start with the common law trust as a business entity. So here's John's Columbia paper that it achieved many of the features of the corporate form, but with the further advantage of avoiding the legislative restrictions on the corporate forms. That's the story that we understand of avoiding limitations on ownership of real estate and the like. But at the same time, the trust was inferior in some ways. It had a weak asset partitioning, and that's an important Henry point I want to come back to in a second. There were questions about limited liability, mismatch and default rules. There's some question about whether courts will apply corporate or trust law. I'm going to come back to that in a moment. But it's against that backdrop. It's against that backdrop of uncertainty about the aptness of the common law business trust that we get the statutory business trust legislation that, roughly speaking, does one big thing. And that big thing is a specialized hybrid entity. It entitizes the trust or trustifies the corporation, whatever you want to think of this. It's really an entitization of the common law trust, recognizing it as a standalone juridical person Or another way to think of that is a trustification of a corporation. Take a corporation, strip out all the corporate stuff, and just give it trust, freedom of design. Okay, so before I get into these statutes, let me draw a picture so that we can all kind of see things the way Henry sometimes sees this, of the role of personhood. So here's T, here's our trustee, right? Here's T, here's our trustee. Trustee's got two different types of creditors. It's got creditors of the trustee as trustee. That's kind of the office holding fiduciary creditors. And the trustee can also have personal creditors, right? You make me trustee of a trust for your spouse and children. You know, I've got a mortgage on my house, so I've got Bank of America as a creditor of me. But also, as I transact as trustee, I've got obligations to the parties with whom I contract in my capacity as trustee. The hard problem in the common law of trusts is how sharp to draw a line between me personally and me as trustee, right? How fluid, how porous is that distinction? Because my creditors as trustee, we don't want them going after my personal property, and my personal creditors, we don't want them coming after the trust property. And this is that nice paper by Henry and Mattei about the trust as organizational form. It is, in fact, a very modern and very American trust law development that dotted line you see on the screen has become sharp, that we have a strong distinction between the assets held by the trustee in a personal capacity from the assets held in a trustee capacity. Until outside of the U.S. and only in the recent decades within the U.S., if I was trustee, you sued me personally and I got indemnified out of the trust. So we can right away see how ill-suited that is to enterprise organization, right? The notion that I'm going to sue, I'll sue Mark Zuckerberg, and then he'll indemnify himself out of Facebook property. So how does that background play into our evolution of the statutes? The statutes come in 4 generations. The first generation, it's not really a statutory business trust. It's a recognition of common law business trust through registration. Modeled on the English Company Acts, it's a registration stuff. This is early 1900s. In the 1960s, we got a second wave, a second generation of business trust statutes. But what I want to suggest is they're not really business trust statutes. They are corporation statutes in disguise. In the 60s, Congress said you can have REITs, real estate investment trusts, that have a favorable tax treatment. But to get the favorable tax treatment, you must be an association or a trust, not a corporation. So all kinds of states, 15 states, passed statutes that were not corporation statutes. They were corporation statutes that just were like Control F, find and replace. Every time it says corporation, make it say trust. Right? It's not really it's just a tax arbitrage. It wasn't really until the 80s that we get real statutory business trusts. We get these kind of third generation early proto business trust statutes in Ohio and Pennsylvania. These are business trust statutes because unlike the second generation, which had corporate law defaults, they just changed the name to play games with the tax code. These are trust law statutes that adopt trust law defaults. It's Ohio and Pennsylvania. Why? Because a guy named Mendelson in Ohio and a guy named Clark, some of you know him, Bill Clark in Pennsylvania, thought alternate entities were kind of cool and they could do things with it, and they got their legislatures to do this. Where the statutory business trust really took off is beginning in the late 80s, right into the 90s and 2000s, when Delaware enacted the Delaware First Business Trust Act and then later relabeled the Delaware Statutory Trust Act. There are kind of half dozen or so mimics that have enacted statutes that look a lot like the Delaware Act, and then the Uniform Statutory Trust Entity Act, UST is what we call it, which has a couple of enactments. UST really follows the Delaware Act, but in a non-crazy organization. Right? It's not just the opinion letters strung together. It's now in a kind of coherent sequence. All right, so what does that look like? Here's a picture of what the US looked like as UST was hitting the scene with the 4 generations of business trust statutes. All right, so let's go quasi empirical for just a moment. What do we know about the usages? And then we'll give you to kind of lay out the simple cost benefit thesis that John and I are developing, and then open the floor for questions. All right, so first of all, here's some formation data. Here's Secretary of State formation data on statutory business trusts in Delaware versus registered common law business trusts in Massachusetts, home of the Massachusetts Business Trust. The boldface number is total number. The italics number is new formations. Why are we showing you these years? Well, part because that's where we have data, because this is when the Delaware Trust takes over, right? It's in the early 2000s that the Delaware Statutory Trust is now clearly dominating the Massachusetts Business Trust in both total number and also obviously by orders of magnitude, the numbers of new formations. So here's an example of a niche. Here's some data from the ICI on state and form of entity for open-ended mutual funds. It's in the early 2000s that the blue line, the Delaware Statutory Trust, really starts to race up. Whereas I'm doing something on my screen, like you can see it. I'm pointing. That's not going to work. It's not going to work at all. So the blue line is the Delaware Statutory Trust racing up. Everyone else is flat, right? Your Maryland Corporation is starting to decline. Massachusetts Business Trust is flat. It's the Delaware Statutory is really racing. Racing up. So we see right away in these niches, we see both with these data that how the Delaware Statutory Trust is just utterly dominating Massachusetts common law and also beginning to take over in its niches. So why? Why is that the case? Well, here's what John and I are going to suggest. So versus the common law business trust, what the statutory business trust does is it resolves the uncertainty. It resolves the incompleteness of the common law. And that's the political economy of the statute. That's why RLF went to the legislature and said, please enact our opinion letters because we would like statutory certainty. What's the problem? Some states had case law that said that you're going to treat your business trust as though it was a corporation. We're going to apply our corporate code to your out-of-state trust. There's less certainty. There's divergence in the authorities on whether we apply trust law or corporate law. There's also tremendous awkwardness from the lack of legal personhood. So the absence of the legal personhood means you have to sue and transact. You're counteracting your contractual counterparty is the trustee as trustee, right? I got to sign this contract as trustee, and then we have to go through this whole rigmarole of weak asset partitioning within the trust. So this asset partitioning weakness is absolutely repaired by having the statute. The trustee, instead of dealing with trustee personal liability and doubts about the limited liability for the beneficiaries, we now have corporate style legal personhood with corporate style entity sharing, corporate style asset partitioning. That is obviously very hard to clean up without a statute, right? You can't contract for third-party effects. This is Henry and Renier, the essential role of organizational law. You need to move from the common law business trust to the statutory trust in order to get these organizational law third-party cleanup effects. So how about the corporation, right? How about statutory business trust versus the corporation? This is that fundamental question that Henry posed at the, I think it was the Aaliyah dinner at the Supreme Court. Anyway, it was the one that became the ALER article. You know, why not? Why are we not seeing the statutory business trust? Well, there are advantages and disadvantages relative to the corporation. So relative to the corporation, we get some fun regulatory arbitrage with the statutory business trust. We can avoid some corporate state governance rules and have diminished shareholder governance rights. We like that in mutual funds. We might not like that in operating enterprises, but we sure do like that in mutual funds. We also like regulatory arbitrage in federal law, variously tax and bankruptcy, that's debated, in 40 Act and REIT or special cases. These are all places where the contractual flexibility and specialized provisions within the Statutory Business Trust Act, series and the like, and the name, allow you to plug into these federal regimes. The series feature is a nice example. The series of the statutory business trust allows the business trust to be one legal person for every single thing except for creditors. So for creditors, every fund within the complex is its own person, it's its own entity. But when I register with the SEC, it's not a new registrant, right? It lets me be one person sometimes and be multiple people other times. That's unique to the series feature. Another example is the name of the act. In the early 90s, Delaware changed the name from business trust to statutory trust. Why? Because they thought that would make it more bankruptcy remote. Where that works is a whole fun other discussion, but it's kind of specialized features within the act for these purposes. So these are new technologies and custom provisions for the niches: limited shareholder governance, changing the name for securitization, series feature for mutual funds. Well, that sounds great, right? What are the disadvantages? Well, I think the disadvantage is what keeps this mule in its particular, keeps it sterile, keeps it in its particular niches, right? What are these? Well, one is there's some real mismatch between trust law and operating enterprise. What we've come to learn when looking at this stuff is nobody in operating enterprise wants trust law fiduciary duties. Trust law fiduciary duties are both more robust and they're different. The prudent investor rule, the no further inquiry rule of loyalty, the duty of impartiality. Trust law has evolved. It's what I teach for a third of the semester every year. Trust law has evolved all kinds of specialized rules for donative transfer down the generations that reflect the governance problems of minors and unborn persons and the agency problems between them and the trustee that don't fit large scale operating enterprise. And indeed, what we've learned from the Delaware practitioners is when they draft statutory business trusts, they routinely negate trust law defaults. The statute provides trust law defaults, but the contractual reality is they're going around it. Trust law also brings with it ancillary law that doesn't make any sense in an operating enterprise. Spendthrift, perpetuities, Claflin modification and termination, all of the collective decision-making rules and non-delegation, trustee removal and replacement. They have all been refined across the decades and centuries for the governance problems of donative transfer down the generations. They have not reflect the evolutionary pressures of management of an ongoing enterprise. You could contract around all that stuff, or you could just use a corporation or an LLC or an entity that has more apt defaults. Right? There's also some doubt about the internal affairs doctrine. There are these lingering case law in the states from the early 1900s where courts said, I'm going to apply corporate law to your Massachusetts business trust. You can't avoid my public policy limits on corporations by calling yourself a trust. What happens when I take my Delaware statutory trust into that state that has that precedent from 80 years ago? I don't know. So what do I want to take on that risk? Well, maybe if that state litigation doesn't matter in my niches, but it might in ongoing enterprise. Okay, so let me wrap this up so we can get to some Q&A. So what's our basic claim about the niches? I want to wrap this out with our basic claim, and then I want a little coda, and then open the floor to discussion. So the basic claim is that there's a different cost-benefit trade-off when we are in versus out of the niches. Within the niches, the specialized technology solves problems and allows for regulatory arbitrage. Outside the niches, the costs of this hybrid entity don't fit, right? Why don't we all just use mules for everything? We still have horses, right? We don't just use the mule for everything because the mule fits its niches, but not everything else. And part of that idiosyncratic niche is, to bring it back to Henry and the suggestion in the 2006 piece, is if you need to update all the documents for all mutual funds or all securitization, you just change the Delaware Statutory Business Trust without affecting everybody outside the niche. Right? You can get global updating within the niche by changing that statute without messing around with enterprise organization generally. Okay, last thing I'll do, and then we'll open the floor. A little coda, which is a little glance abroad. And I think this is part of the puzzle of why nobody really has done, and nobody's looking at business trust, and we're not really understanding its role as an enterprise organization. So I think US practice is meaningfully different than practice outside the US in trust law. And here's a claim we want to suggest, and we think it has some explanatory power. The US has robust freedom of disposition. That's donative trusts. That's what I do most of the time, right? That's what I'm teaching. The US also has robust freedom of contract. That's business trust, right? Another way to say this is, when you make a trust in exercise of your freedom of contract, you're in the business trust branch of trust law. When you make a trust in exercise of your freedom of disposition, that's the spouse and children and descendants, you're exercising your freedom of disposition. So it's not surprising, given US has robust freedom of disposition and freedom of contract, that we have robust business trust law and we have robust donative trust law. In fact, John and I, in a 2020 piece, make the claim that these are two different branches of law, right? These are two different fields now. The corporate business trust and donative trust, they have a common history, but they are so different now. They're different branches. Outside the US, and in particular outside the common law countries, we observe much less robust freedom of disposition, right? Nobody allows you the same freedom of disposition. Not even England gives you the same freedom of disposition that the United States does. And so with less robust freedom of disposition, you see less and less well-developed donative trust law. But with robust freedom of contract, you do see a lot of interest in business trusts. So when you're outside the common law world in particular, and folks talk about trusts, we see the development of trust in Asian countries and the like, it's for business trust purposes. And it's for business trust purposes because it's a freedom of contract application. Looking to US practice as a model is inapt when you confuse donative trust with business trust. So underlying this project and underlying our answer here is that these are different areas, right? These are just different creatures now, commercial and donative trusts. All right, so that's my, I'll stop the screen share. That's my, that's the thing. Let's open the floor. Thank you.
Thank you so much. So we've got several questions in just a few minutes. So I'm going to take them as a whole. So Albert and then Ian. And then Rob, you'll have a chance after we have a few questions. Thanks.
Hey, this is a really fascinating project, very interesting data. Just to get a little bit more idea about these competition among business entities, I was wondering first, do you have any data or idea on possible conversions from, let's say, business trust to other kinds of forms or vice versa? And then the other is, what about, let's say, I feel like you're sort of focusing mostly on mutual funds and securitization. What about in those areas where they're doing this with other forms? Another big kind of enterprise form that has always puzzled me are the LLCs, for instance, which are supposed to have the beneficial features of all enterprise forms. And then again, they still have not kind of taken off. So I was kind of wondering about whether or not so you have some more ideas or data on conversions or forming utilizing different kinds of business entities in those specific areas as well.
Yeah, so
oh, hang on a second, Rob. We're going to do Ian and then Henry and then Jill, and then you'll have the last minute. Thanks.
A small recharacterization is that instead of saying that the mismatch in default rules is a disadvantage, shouldn't you be saying that the real problem is that there aren't sufficiency altering rules? And basically for Bernie Black's triviality of corporate law, default choice shouldn't matter much here. The cost of contracting would be cheap if you knew that if you do this, it will be sufficient to get you around the default. So you could say uncertainty about whether some of these rules are really mandatory or this absence of clear altering rules is the real problem.
Henry.
Yeah, this is a wonderful work, I think, as both John and Rob know, I think. And one question I have is recognition of the trust as an entity for different purposes. And for example, 30 years ago, the French Parliament considered, as I understand it, the adoption of a trust statute and rejected it, to the surprise of all actors involved, I think. But the reason they rejected it, as I understand it, was that they were worried about the consequences for various areas of law, and especially for tax law. They thought that the tax law was tied to the organizational law, to the corporate law, and the way you were taxed was dependent upon how you were organized under the organizational law. So, so they were worried about suddenly exempting from tax all French corporations. The United States, in contrast, the tax law regulations of entity forms are attribution of liability to tax liability to entity forms is tied to the tax law. The tax law has its own special provisions describing what kinds of entities qualify you for exemption or not. And we have developed a system of law that where each branch of law creates its own rules for entities in particular. When does liability go across the line or not? When is liability limited? When is tax liability limited? Those can be answered differently, easily in the American system. It couldn't in the French system. So, so there may be a question of for what purposes are you an entity, and how flexible your law is in sorting out those purposes.
Jill. The microphone, please.
Yeah, it is. So following up on Albert's question, when I teach entity law in corporations, I teach corporations and LLCs and partnerships, and then I kind of throw in business trusts without any real rationale for how or why they're different. And in your story, in which you focus largely on this freedom of contract approach, I have trouble seeing the difference. And I'd kind of always thought that it was things like, different fiduciary standards or something like that. So maybe for those of us who are not trust experts in the room, you can at least give us another sentence to tell our students about the difference. And I mean, I recognize there are differences in tax and bankruptcy and so forth, but from an organizational law perspective, since that's obviously, the focus of this conference.
All right, we've just got 1 or 2 minutes left, so I'm going to give the time back to Robert. Over to you.
All right, thank you. So 1 or 2 minutes. Let me tie Jill and Ian's question back together. I think they fit really nicely, and I think it's a little bit loose talk to say mismatch and default rules. That there are default fiduciary rules, there are mandatory rules. There are aspects of the common law trust that are mandatory, that in a numerus clausus sense, and it's unclear you can get out of these modification, termination, and trustee removal rules and the like. So I really like both of your points fit nicely together. That we really need to talk about is the sufficiency or ability to truly contract around some of the trust stuff that comes with that apparatus. For Albert, when I started collecting this data, that we used to write letters to Secretary of State's office. So that, now that it's computerized, maybe we can get conversion. I just don't know the answer to that. As for, a grand theory of other entities, I feel like this is a big enough by itself. We can come to LLC later. The thing I wanted to take the rest of the minute I have was about Henry's comment, an entity. And I think, Henry, you're right about that it's an entity for some purposes and not for others. The story of the rise of these statutes is the entitization of the trust for creditor purposes, where and in a statutory way, whereas it had been an entity for tax purposes, it's sometimes an entity internally and not otherwise. And I think your tax analogy is really apt. And even within the tax code, the same trust is a separate entity sometimes for income tax, but not for estate tax. I think that's just right. And that we see this in donative trust too, that the trust is increasingly entitizing for more and more purposes, but a purpose-based understanding of when something is or isn't an entity is a richer and more nuanced account than just a binary. Entity status really is maybe a spectrum, and your entity for some purpose and not others. And that's a well-taken point that will add to the clarity of the paper. So thank you.
The range of the works on this panel really are a testament to the breadth of your work, Henry, and the elegance of it as well. Thank you so much, Robert. That was fantastic. And now over to you, Richard. And thanks to you, Richard, as well, for all of the work that you've been doing putting this together. We're so happy to see you and glad to have you next.
Thank you very much, Elizabeth, for moderating this panel and also for those kind words. I'm going to start with some preliminary remarks about Henry before talking about the project. It's a great joy to be presenting and to be part of this very distinguished panel. And this event is just a joy to be viewing. And I'm just very excited about all of the work that we have been talking about and the opportunity to talk about Henry's work. And as has come out, and so this is where I'll kind of start, I think it's been clear from many of the presentations yesterday and today that although this event is, the occasion of this event is the anniversary of the ownership of Enterprise, that is by no means Henry's only highly influential work. This is just, I just pulled this off of Henry's faculty page at Yale, just a short selection of papers and books that he has written in addition to ownership of Enterprise. In fact, all of these are just since the ownership of Enterprise. So it's just a small selection that have also had a tremendous amount of influence. And Henry modestly last night attributed the influence to the titles and said that they exaggerate. And I don't think that's true. I think that Henry does have a great ear for titles, but almost all of these works really are, they have a broader expansive title because they seek to make a broad contribution, and many of them have. We just heard from Bob's work, for example, that the essential role of organizational law, which is last on this list, but by no means least on this group, introduced asset partitioning, which has also been tremendously influential. Of all the titles on this list, I just want to call attention to one. It's this third to last bullet point, Law and the Rise of the Firm. What a broad and stirring title. One of Henry's co-authors on that paper wanted to call that piece The History of Asset Partitioning. And it wasn't Rainier who had that idea. And Henry was very smart to say, no, we could do something better. And he was right about that. And speaking of Rainier, it was Rainier who brought me to Henry's work, because when I was in my last year of law school, I need to write my third year paper, and I was taking a seminar, and Rainier gave me a copy of The Essential Rule of the Organizational Law, which was hot off the presses from the Yale Law Journal. And I read it, and Rob Jackson told a little bit of a story yesterday about what brought him into legal academia. Well, this was the piece that did it for me. I read this, and it just revolutionized not only the way I thought about business corporations and other legal business organizations, but also revolutionized for me what was possible, or what I thought was possible in legal scholarship. And one thing, an additional thing I like about this piece and why it's inspired me is the claim in the essential rule of organizational law is that the most important thing that legal entities do is allocate creditors' rights. And if you think about what happened there, just a few years earlier, Henry had written this book, The Ownership of Enterprise, which is all about the allocation of equity claims or residual claims if you're not talking about owners. So it was all about equity. It was all about the owner side. And then he comes along a few years later and says, yeah, despite all that, something even more important in organizational law is creditors' rights. So that's it was like a revolution one after the other in terms of thinking about the field. And my own scholarship has really been inspired by that ever since. I write about corporate law, but I'm typically, and also in the piece I'm going to be talking about today, writing about creditors' rights within the context of corporate law or corporate entities. And it's Henry and Rainier's work, starting with there, that has been my influence. The list that I was showing you has other co-authors as well. One of the wonderful things about Henry is that he brings on co-authors and gets them going in their work as well. And many of them are presenting in this conference. So I heard a bit of an echo there, and if there's a problem with my audio, let me know. Today's piece that I'm talking about is I'm co-authoring it. I'm honored to be able to co-author it with Zohar and also with Felix Stefik from Cambridge. And taking a page from the Henry playbook, we have a broad, I don't want to call it grandiose title, The Law of Corporate Debt, a Unifying Theory, but we're going for something on a high level of generality in this piece. And so what are we doing here? So what we've noticed in thinking about corporate debt and relationships between businesses more broadly and their creditors is that all of those relationships, or almost all of them, start with a contract, a debt agreement, or a credit agreement of some type. But then there's a whole slew of positive law mechanisms, most of them statutory, although a few are judge-made common law, but they're non-contractual mechanisms that augment, amend, or override aspects of these private debt agreements. So you've contracted a lot of that's working it has a quasi-mandatory quality that's overriding or modifying these contracts. This is just a few examples, maybe some of the most obvious. There's bankruptcy and insolvency law. There's also fraudulent transfer law, the law of secure transactions. There's the veil-piercing remedy, equitable subordination, distribution constraints, restricting dividend payments, and so on. All of these are going above and beyond what you just get in your debt agreement, and some of them override what you would otherwise want in your debt agreement. Bankruptcy is certainly an example of that, but fraudulent transfer law does that as well, and secure transactions can do that. So our question was, do these mechanisms, which we're calling the law of corporate debt, we might call it the positive law of corporate debt, do they have anything in common? Well, if you go back and if you look at both the legal scholarship and also what judges say about these mechanisms, they don't identify one single purpose for all of them, or to the extent that they do, they speak in broad terms. And this is just a very small sample of our research in this area. But if you look at just bankruptcy law, I'm pulling a Harvard Law Review here piece from Professor Jay Westbrook. This statement he makes here is authoritative. It's very typical. He says the primary goals of the bankruptcy system are to maximize wealth, collectivize risk, and to reduce the ex-ante cost of credit. That's all true, I think. But there's a high level of generality there. If you look at secured transactions, here I'll give you a quote from the Eighth Circuit. The primary purpose of Article 9, which is secured transactions on personal property, not mortgages on land, is to facilitate efficient and effective financing, allow creditors to allocate the risk of providing credit. Certainly true. Fraudulent transfer law, there was an important piece by Doug Barrett and Thomas Jackson back in 1985, and they were talking about this in the context of LBOs. And they said, the reason we have fraudulent transfer law is so that a debtor cannot manipulate its affairs in order to shortchange his creditors and pocket the difference. That's absolutely true, but these tend to be talking about different things, or it's hard to see, is there a specific problem that they're all dealing with other than there are problems in debt financing. So what we endeavor to do in this project is to say, we're going to try to find a single purpose, a single problem, if you want, for all of these different positive law mechanisms, or a problem that they're all responding to. And we start by importing, to a certain extent, or transposing a framework that Zohar and I introduced in an earlier paper, this paper, Principal Costs. And in that paper, we broke down the costs of controlling a business enterprise into 4 categories along 2 dimensions. We looked at the principals and the agents. The principals you can think of as the investors, the agents, or the managers in a corporation. And then with each of them, they can generate, when they exercise control, conflict costs, which arise when the person exercising control puts his or her own interests above the interests of the collective, of maximizing the value of the organization. And there are also competence costs, which arise when a person is acting in good faith, is trying to maximize economic value for the enterprise, but makes a mistake. So an honest, good faith mistake. Competence or incompetence is the reason we have delegation, why managers are hired in the first place, because investors, one of the reasons why investors hire managers, because the managers will typically be more competent. Now, we were talking in that paper primarily about shareholders and managers, but if you step back and you just say it's the person who initially has the capital and then delegates it to someone else, the framework can also be used to talk about creditors and debtors, because a creditor also is an investor, provides capital, and the debtor, or if you want, debtor here could also mean the shareholders, the residual claimants, the persons to whom the capital is being entrusted. And then within that framework, there are 4 categories of costs. There are principal conflict costs, or in our framework now, creditor conflict costs, which is when creditors exercise control, but they do so in a way that puts their interests above the interests either of other creditors or debtors. Debtor conflict costs, creditor competence costs, and debtor competence costs. Our claim then in this paper is that the positive law mechanisms that we're talking about, the law of corporate debt, are designed to reduce the upper 2 boxes in this 2x2 framework, conflict costs. They are designed to reduce the creditor conflict costs and debtor conflict costs. And so that is the unifying purpose we are proposing for all of these mechanisms. And our proposal has both a descriptive aspect. We're saying that most of these, if you dig down, they do seem to be responding to this problem of conflict of interest, but also there's a prescriptive aspect. We think that these mechanisms should be designed to focus on that, and they should not try to do other things. And so these costs, these mechanisms we propose should be reducing are the conflict costs of debt. And importantly, beyond the point that parties could reduce them by contract alone. Contract law is primary here. There's an augmentation going on of contract law. The conflict costs of debt result from the fixed prior structure of debt claims. This fixed nature of a debt claim introduces a structural conflict of interest that one could argue contract law cannot solve in the most cost-effective manner all by itself. At least that would be the best rationale for these various mechanisms. The structure of debt claims introduces two problems. One problem is debtor misconduct, which arises when the debtor or its agents exercise control, and they do so in a way that put their own interests above the collective interests. That's actually a more specific definition I can give, a little more rigorous. And then creditor misconduct, when creditors do the same. The term misconduct sounds moralistic, but we think we have an objective definition of it. We're not trying to make a moral claim here, other than to say that this type of conduct that we're talking about is conduct that the parties would ex ante, if they could write a complete contract, agree that the other party or that they themselves should not engage in. So it's conduct that reduces the pie, and so ex ante they would agree not to do that. Rather, they would want to maximize the value of the firm and then use the interest rate to divide the surplus from it, and other maybe in a bankruptcy, the collection, if we get to that. But contract law does not enable them to completely, in the most efficient way, at least in many cases, minimize these conflict costs of debt or prevent debtor misconduct and creditor misconduct. And so these positive law mechanisms can play a role. This is just my very cartoonish. I'm not very good at PowerPoint, but this is just to illustrate a little bit what we mean about these conflict costs of debt and how they're related to the structural conflict of interests introduced by debt. Here's a very simple model of not a model, an illustration of aspects of a company's balance sheet. We have liabilities that reach to a certain level, call this $100 worth of liabilities. And then there are assets, and the assets can rise in value or fall in value, making the company either solvent if the assets are up here or insolvent if it's below the line here. The problem with debt claims and how it relates to the allocation of control rights is that when the company is solvent, when the assets are worth more than the liabilities, any exercise of control that is given to creditors, so the ability to enforce covenants, for example, or maybe accelerate a loan if an interest payment is missed, even though the company is solvent. The creditors in this area have residual gain indifference. They don't really care very much about value creation above the point of solvency. They want a bit of a cushion. But beyond that, they don't care because the upside is going to the equity holders. So if you give the creditors control, then when they're thinking about the solvent states of the world, they are going to engage in various forms of misconduct that are value destroying from the collective perspective. Similarly, when the company is insolvent, when the assets are worth less than the liabilities, the equity holder, the debtor itself, if it's just a sole proprietorship, but the model works that way as well, have residual loss indifference. They don't really care about losses beyond the point of insolvency because all the losses then are externalized to the creditors. This is a familiar way of talking about this problem to a certain extent. We're just trying to use some terminology here, to characterize the problem in broad terms, the residual gain indifference, the residual loss indifference. So, like I said, debtor misconduct results from residual loss indifference. Once a debtor is insolvent, further losses fall on the creditors. All kinds of mischief debtors can get into, or managers who are more disloyal to shareholders, or maybe the managers are shareholders, can get into in this situation. There's the overinvestment and asset substitution problem. There's a lingering for resurrection problem where the company's insolvent, it probably should liquidate, but you hope that things will turn around in the future, even though it'd probably be better to shut the company down at this point. Debt dilution can be a problem, voluntary subordination, correlation seeking, and so on. These are different species of debtor misconduct, and we claim that all of them are ultimately attributable to the residual loss indifference when you have debt. And the debtor or people loyal to the shareholders, loyal to the debtor exercising control. How can you prevent debtor misconduct? Well, you certainly can do it by contract to a large extent. There are financial covenants and acceleration clauses. The biggest problem is with contract in this area in particular is the damages, which is the normal contractual remedy, are ineffective against an insolvent debtor, and a lot of the misconduct is not discovered until insolvency. And so we think that a lot of these legal mechanisms are trying to provide other remedies. So security interests, fraudulent transfer law, avoidable preference rules, these are all giving a quasi-property interest in the assets to the creditors because the contractual interest they have may be insufficient to fully protect them. Creditor misconduct resulting from that residual gain indifference. This is because when a creditor is exercising control, the creditor just wants to recover the maximum amount that he or she is contractually owed, and any value destruction beyond that's externalized to other creditors if the company is insolvent, or maybe the shareholders of their solvency. These species of creditor misconduct have been recognized by others. There's the race for assets, which can undermine going concern value, create payout variability. There's a redundancy in the collection efforts that bankruptcy law, one rationale for it is that it replaces those redundant collection operations with a single kind of it's like a collective action or a class action. That's the term that I'm looking for. But there's other problems that result from residual gain indifference. For example, if a creditor forecloses on assets, sees them, and then runs an auction, there's actually a problem. The creditor really doesn't care if the auction price of the assets that are seized, if it's collateral, exceeds the amount that the creditor is owed, because then the price, anything collected beyond then goes to other parties. So 363 sales, if you're familiar with the bankruptcy area, are characterized to some extent by this residual gain indifference problem when creditors are ultimately running the show. Collective action problems in bond indentures, collective action clauses in bond indentures are a contractual way to deal with some of this, but there are limitations in contract law as well, lack of privity, and so on. So you get these positive law mechanisms. I'll skip the trade-offs of what I'm talking about here to make one more claim, and then I'll stop. We were saying, or I was saying, that we make a descriptive claim to a certain extent, but we're also making a prescriptive claim. We're saying that not only should these positive law mechanisms focus on conflict costs, but they really shouldn't be concerned with competence costs of people making good faith mistakes. Those really should be left to contract. And there's an example of coming out of securities law of a legal mechanism that would fall into the positive law area that we think is a bad idea. And we're not the only people who think this. Mark Rowe has written about this as well. And it's kind of the definitive work here is the Trust Indenture Act, which is really a mechanism for overriding a contractual solution to collective action problems amongst creditors. It allows a bunch of creditors to, in a bond indenture, to vote collectively, let's say, on a workout, and this voting, where a majority or a supermajority binds all of the bondholders, prevents holdout problems. It overrides holdout problems. And Congress, in its great wisdom, in the late 1930s, enacted the Trust Indenture Act, which prevents these collective action problems from being, these collective action clauses from being effective. And the only possible rationale for something like that would be, well, there's kind of paternalism here. You don't think the creditors or the bondholders know what they're doing and they're getting duped. And that's not about the structural conflict of interest. That's just competence costs. And one trade-off that's evident is when you try to reduce these competence costs, you end up increasing conflict costs because now we have more of a collective action problem that we can't fix by contract. And so prescriptively, we say that that's a bad idea, that the positive law of corporate debt should not focus on that aspect of control costs, not on competence costs, but on conflict costs. Okay, I will stop there. I think this panel is supposed to go to 11, so I think I'll take the rest of the end.
Thank you. Henry?
I think it's a fascinating presentation, very interesting, providing the unifying theory. I had a question though. The underlying assumption in terms of how you analyze creditor misconduct assumes, in effect, that the creditor misconduct can only occur when the assets exceed the liabilities. But in fact, for instance, if, the assets are below the liabilities, there could also be creditor misconduct, right? So for instance, in terms of the empty creditor with negative economic interest context, right? So that a creditor uses his control rights to deliberately cause a company to go bankrupt, even though basically it can survive, simply because it can make money off of the credit default swaps it had bought way in excess of its exposure to the debtor. So, that underlying presumption, while generally good, has important exceptions, may have important exceptions.
Should I respond now, Elizabeth, or should?
Please go ahead. Thanks.
Okay, great. So thank you for pointing that out. You're absolutely right. And when I was trying to illustrate this problem about solvent versus insolvent debtor, I was talking about one aspect of the residual gain and difference. You could think of that illustration that little cartoonish illustration that I had it makes the most sense if you're thinking about just one creditor. If there are multiple creditors, then the residual gain and difference attaches or arises not when the company overall is in the money or not in the money, but simply when the creditor is in the money or not. So even if the company is insolvent, so there's not enough money to go around, a creditor will attempt to, in that situation, maybe maximize his or her recovery and then not care about value destruction beyond that amount, which will, in the insolvent company, be externalized to other creditors. So you're absolutely right. The residual gain and difference problem with creditors is not solely when the company is solvent. It's whenever the creditor sees a possibility for maybe him to be solvent or her to be solvent, if you want. Like, I can maximize or I can collect everything I'm owed. But by doing that, I might impose costs on others. You're absolutely right about that.
Just 15 seconds. But quickly, you don't necessarily want to frame it in terms of recovery. That is, the creditor in my instance is not recovering from the debtor like gains at the expense of others. He's collecting money from the derivatives dealers who had sold him the credit swap protection, right? It's coming from third parties.
And using the control rights over the company to trigger the credit default swaps.
Exactly.
Got it. Yes, that's something we don't talk about that. And that is an additional aspect of this that we certainly should talk about. Thank you for that, that improvement or expansion upon what we're talking about.
We've got a queue now, Richard. So we're going to go to Patrick, and then down front, and then back again. So we're gonna batch a few now. Over to Patrick.
Okay. I'll hold my tongue until the end.
Thank you. I just want to make a small comment on your last point on the Trust Indenture Act. So the way I understand it, it was really to get the parties to do resolution under the new Chandler Act, under the supervision of the court, which was fairly interventionist in terms of weighing the interests of creditors and debtors over more broader interests of the community. And you see the same kind of issues arise today with respect to resolution of systemically important financial institutions. These institutions would like to get resolution under Chapter 11, where they control the process, rather than under orderly liquidation authority, where you have a much more interventionist procedure with broader interests brought to bear financial stability. So I think it's not just paternalism here. There's a broader issue. When it comes to resolution, should we just look at creditors and debtors, or should we also look at the effects on the broader community?
Okay, down in the front, Victor. Yep, is it Victor? Oh, Alan, of course. Sorry. The mask. Yes, please go right ahead, Alan, if you're ready.
There was an awful lot in this paper, Richard, so I only have a question about one little part of it, but obviously we'll all have questions about lots of parts of it. I think I'm a little concerned about the point you made about creditors not having an incentive to maximize when they repossess. I think that is not a danger if the value of the debt exceeds the value of the assets. Because if the value of the debt exceeds the value of the assets, then the creditor wants to maximize the value of the assets, which is socially what you want the creditor to do. So the problem, I think, arises if the value of the assets exceeds the value of the debt. But what that would mean is that the debtor has equity in the property. But if the debtor has equity in the property, the automatic stay would kick in and the creditor can't repossess. So I guess I'd like to know just how serious that problem of creditors not maximizing is.
Thank you. Thanks, Alvin. Dave.
Hey, Richard. So this is a really interesting project, and my question is about how fiduciary duties of corporate managers might change at the zone of insolvency and when a company goes bankrupt, and just where you, Zohar, and your other co-author would think about situating that within your framework. So arguably, whether creditors can bring a derivative lawsuit goes to competence costs, I guess, and to whom fiduciary duties run goes to competence, maybe. And so is that part of the general law of debt, how we think about fiduciary duties around the zone of insolvency and in bankruptcy? And if so, where does that go into your framework? You want to have mandatory default rules about that, et cetera. So that's just a question.
Okay, and the last quick question goes to Zen, and then it'll be back to you, Richard.
Now I can see the face of the Professor Rasmussen in the Zoom. And recently I read a wonderful paper, the Baird and the Rasmussen in 2006, private debt and its missing level of corporate governance. It nicely articulated that how these senior lenders can promote their own economic well-being by maximizing the value of the business. My question is, their paper is conflicting with your theory of the conflict cost of creditor. Thank you.
Thank you, Zen. Safraz, I think your hand was up for the last time, so I'm going to give the floor back to Richard for, oh, no, you have a question for Richard?
I have the question for Richard. So Richard, this is a really fascinating project, and thank you so much. What I wanted to ask, when you talked about creditor costs and about competence costs, I thought about the Citibank Revlon case, which is the case where Citibank accidentally wired $900 million to the creditors of Revlon, and then the creditors, the case is currently pending, but the creditors basically got to keep the money after it was a mistaken transfer because of a unique factual situation. So how would the framework proposed in your article, in your and Zohar and Felix's article, how would it address a situation like what happened in Citibank, which is, to put it simply, it's a weird case, right? It's not something that would happen every day. How would you ex ante deal with these kind of unexpected things that can happen in the corporate debt relationship?
All right, a minute or two, the impossible task.
Oh dear. Well, I'm very excited that people have many observations and questions. I'll try to be very quick here. With respect to the Trust Indenture Act channeling people into bankruptcy, I think that is a purpose as well. That's right. And I think that other purposes, broader social purposes, protecting the community and so on, have been attributed often to bankruptcy. And so you can see the Trust Indenture Act as a way to channel companies into the bankruptcy law. We might propose that those are not legitimate purposes of bankruptcy law, that there's an opportunism going there. Now we're not talking about systemically important institutions where there might be real externalities. So the analogy to what Dodd-Frank created for systemically important institutions is an important one because there is a broader social purpose there. But I guess we're making an aggressive claim there that we think that that's trying to do too much with bankruptcy law, but you're right historically. Alan, you said there's an awful lot in the paper. I'm guessing that the emphasis is the word awful. But on your specific question, I would like to hear more about your instinct that if the liabilities or the assets are worth less than the liabilities, then the creditors have an incentive to maximize the value. I think that the creditors collectively have an incentive to maximize the value, but if the creditors are competing with each other, for example, if you have a secured creditor who is running an auction, I think the secured creditor just wants to recover up to the amount that he or she is owed, even if there is additional value potentially beyond them, but it's less than what the unsecured creditors are owed. So that's what I had in mind when I was talking about the insolvent firm and the conflict among creditors there. Fiduciary duties, the fiduciary duties have largely been gutted. I think it was Gabe, I recognize your voice, Gabe, your question, and they've been largely gutted with respect to creditors, except to the extent that, at least in Delaware, they're saying, you know, managers, when the company's insolvent, should probably try to maximize the value of the firm. And that's consistent, I think, with our sense that conflict costs arise when parties are not trying to maximize the value of the firm. Then I appreciate the reference to a paper. You asked me to compare it. I'm not familiar with the paper, so I need to go back and do that, but I will do that. So thank you for that. Finally, Asaf, I think that that Revlon example is great because we really have an example of competence costs, making a payment to a creditor the creditor wasn't owed, so that was incompetence. But then the creditor holding on to that money, is that a conflict of interest? I think that our framework would just say, look, or is it misconduct? I think the question would be ex ante if the parties could have envisioned that, and this is a standard gap filling and contract analysis. Would they want the creditor then to be hold on to the money or return it? Either they should contract for that, or if not, and that's the analysis that a court applying any of these principles or these mechanisms should use. Thank you.
Thank you so much, Richard. Thank you to Rick Brooks, Ron Gilson, Rob Sitkoff, and Richard Squire. Thank you so much. And